Oh, it's David Solomon Dwinez.
Yes, ma'am.
All right, court is calling 2023 CR 2677 State versus David Solomon Dwinez. Could I have parties announced for the record
For the state of Texas,
and for the defense?
Raymond Martinez.
And are you David Solomon Dwinez? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? This is incorrect. Let me see. This was a jury trial.
Yes.
Okay. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same David Solomon Dwinez who was placed on community supervision by jury in 2023? Placed on community supervision by the court, which followed the recommendation from the jury, and 2023 CR 2677 for the offense of aggravated assault with a deadly weapon on January 23rd, 2024 for a term of 5 years. Is that you? State?
Violation condition number 1, on or about the 9th day of October 2025 in Bexar County, Texas, the defendant, David Solomon Dwinez, committed the offense of assault on violation condition number 1.
How do you plead to that? True or not true?
Violation condition number 2, on about the 12th day of September 2025 in Bexar County, Texas, the defendant, David Solomon Dwinez, did then and there illegally use a controlled substance, namely cocaine, in violation condition number 2.
How do you plead to that? True or not true? All right, state, call your witnesses.
This time, Your Honor, state will call Terrence Williams.
All right.
And Judge, before they call the number 1, before they try to prove that one up, I wanted the court to be aware that we would prefer to have our jury trial on the number 1 violation. And it's been indicted already. We're ready to go on it as soon as the court could, but because of the different standard of proof, I think, in all fairness, my client should be afforded his right to a jury trial on that.
All right, we're going to proceed. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Terrence Williams.
All right, state, you may proceed.
Good afternoon, Mr. Williams.
Good afternoon, sir.
Could you please introduce yourself to the court?
My name is Terrence Williams. I'm a CSO for Courtroom
How long have you been a CSO with the Bexar County, Bexar County?
since 2025.
In your employment with Bexar County Probation, have you come into contact with someone whom you now know to be David Solomon Dwinez?
Yes, sir.
You see that person in the courtroom today?
Yes, sir.
Could you identify him, please, by an article of clothing that he's wearing?
Black vest, black long sleeves, and glasses.
Mr. Williams, can you please tell the court, when was your first interaction with Mr. Dwinez?
September of 2025.
And at that meeting, did you go over anything with Mr. Dwinez?
Yes, went over acting a series of
Yes,
questions.
been non-responsive, Judge. You just asked him, did he go over things with him? The answer is yes or no.
Yes.
What things did you go over with Mr. Dwinez on that day when you first met him?
So some things I went over were his employment, place of address, and had he had any contact with law enforcement and the police or any arrests.
And what was the purpose of that last question for having any contact with law enforcement or arrests?
The purpose for that question was to determine if he was violating any conditions under his probation.
And what condition of probation would that be?
Violation of committing a new offense.
No further questions this time, I'll pass the witness.
No questions, Judge.
All right, thank you. Is this witness excused or subject for recall?
Excused by the state.
Judge, I'm not really sure what role he plays in the overall scheme of my client's probation. I don't know if he's a regular probation officer or it was just that particular day. If he's a regular probation officer, I'd like him to stick with that.
I understand this offer.
Okay.
All right, so if you could remain. Thank you so much, and thank you for your patience. All right, call your next witness.
Your Honor, this time state calls Ms. Karina Luvano. And if I may just check.
Sure.
Thank you.
Ashley.
And And what is happening with De La O? De La O? What is happening?
So she's back here.
Oh, he is? Okay. I don't know where, I think they went in the talk in the hallway. All right, thank you.
Mayor, while we're waiting, state's not going to waive their right to a jury trial with this number one violation.
Oh, we're not here we're only here on the motion to revoke. Okay,
Apparently she had to leave the restaurant.
okay, that's okay. All right, are you all planning to address violation of condition number 2 or no?
No, you aren't. Just number one.
All right. Oh, while they're doing that, if you could grab a trial court certification of defendant's rights to appeal. I don't know what my ruling will be, but I always require that they are filled out. It's on the wall. Yeah.
That keep it real.
Over.
I don't do oh, all I have done. Oh, all right.
They're waiting for a rejection. If I'm not mistaken. Estamos here.
Revocation, agreed revocation.
All right, if you'll come forward, please. All right, just keep your voice up so defense counsel can hear, I can hear, and the state can hear, all right? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Everyone, please whisper. If you'll state your name for the record.
Lovano.
All right, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Lovano. Do you know someone by the name of David Solomon Dwinez?
Yes.
How do you know him?
My ex-fiance.
How long have you known
Around 5 years.
him? How would you describe the nature of your relationship with Mr. Dwinez?
Can you ask that again? Can you ask that again, please?
How would you describe the nature of your relationship with Mr. Dwinez?
I don't understand. Yes.
Have things always been good between you two?
For the most part, yes.
Have things ever gotten physical between you two?
Yeah.
Was there an incident that took place on October the 9th of 2025 where things got physical between you?
Objection, leading the witness, Judge.
That'll be sustained.
Hold on. Let me throw a question. Let's see the question. Right. Has there recently been an incident that took place between you and Mr. Dwinez?
Yeah.
Do you recall when that was?
Not the specific date, no. I'm going to ask you a question.
No, not while you're under oath.
Okay.
No. So what ends up happening at this stage, they just ask you questions. The state will be able to ask you questions. Just listen to his question, answer his questions. And then if the defense attorney wants to ask you a question, just listen to their question and answer their question. If for any reason you don't understand the question that's being asked, just let them know you don't understand it, okay? Because sometimes attorneys can use a lot of legalese. All right. So if it's something you don't understand, just let either party know you don't understand it, okay?
Can I jump in on that question, Judge, just to clarify for the court?
I can. I have a good question.
No, yes, proceed.
Thank you. Mr. Lerner, do you want to be here right now?
I do not.
You're here because you're under subpoena?
Yes, only because I'm under subpoena.
Well, do you recall meeting with the police recently?
Yes.
Do you recall making a statement to the police recently?
Yes.
We're looking at a copy of the report to refresh your memory as far as when that interaction with the police took place.
Yes.
Judge, I'm going to object to her refreshing her memory with something that's other than her statement. The police report is the officer's version of what he did at the scene, not what she said. She needs to look at her own witness under the Gaskin rule. She's got to see her own statement that she wrote or video statement. Refreshing her memory with somebody else's is inappropriate.
Right?
No, that's not the law. The objection will be overruled.
You have folks witness one?
Yes.
Ms. Silvana, if you could look at this page, please. Look at it to yourself. Do not read aloud from it. And then look back at me once you feel like your memory has been refreshed. Has your memory not been refreshed, Ms. Silvana? Do you remember when this incident testified earlier about things getting physical between you and Mr. Dwinez took place?
Objection, leading the witness, Judge.
Overruled.
October 9th, 2025.
Can you please describe to the courts how things began on that day?
Again.
Can you please describe to the court how your interaction with Mr. Dwinez began on that day?
We had a disagreement.
What was the disagreement about?
Me asking for the apartment key, his copy
Of your apartment?
of his apartment.
Of his apartment. Where do you live?
No longer in that apartment.
Okay. You described wanting a key for that apartment?
Yes.
Why did you want that key?
He no longer lived there or paid bills, so I didn't want him to have access to the apartment.
Okay. At that time, who lived in the apartment?
Myself and my 3 children.
Okay. Do you and Mr. Dwinez share any children in common?
Yes, we share 1 child.
Okay. How old is that child?
She's 3.
It's Elizabeth?
Ariela Dueñas.
Okay. Does he have like visitation rights with that child? With that child, excuse me?
No set visitation rights, no.
Like no formal?
No formal,
Is there
right?
like an informal agreement between you two?
Yes.
Okay, and what is that agreement?
He would just pick her up when he had time or was available.
Is that what he was trying to do on this day?
Yes.
He was trying to pick up the child that you have in common?
Yes.
Okay, and happened when he requested that?
We agreed for him to pick her up.
Pick her up at your apartment?
Yes.
Okay, so did he come to the apartment?
Yeah.
What happened when he got to the apartment?
He went upstairs for my daughter. She was sleeping.
There's in the apartment?
Yes.
Okay, and what happened after that?
After he went upstairs for my daughter, he came downstairs. I asked him for the apartment keys.
What happened when you asked for the apartment key?
He told me that I didn't need it back.
How did he react? I guess what was his mannerism at that time?
Calm.
What happened after that?
He made a comment that upset me. So I guess we got into a disagreement.
Okay, so would that be like an argument?
Yes, an
Argument?
argument. Yes.
What happened after this verbal argument took place?
I don't remember like the specific sequence of it.
Explain to the best of your knowledge. Tell the court what happened after this verbal argument took place.
He I guess charged at me.
Okay, and where were you in the apartment he charged at you?
It's like an open space, so he was closer to the it's all like the same space, but he was closer to the front door and I was in the dining room.
The dining space. So it was at that point that he charged at you while you were in the dining room?
Oh, I forgot that he set my daughter down.
He sat your daughter.
Set her down on
Set
the
her
sofa
down.
as she was sleeping.
Okay, and so it was after that that he charged at you while you were in the dining room.
Objection, leading the witness, Judge.
All right, that'll be sustained.
Was it after that when he charged at you?
Yes.
And what happened when he charged at you?
I don't really remember what arm grabbed my neck or how I was positioned. I don't remember if I gave him my back. Or if it was head front, but his arm or his hand was around my neck.
His hand was around your neck?
Yes.
Do you recall if you were able to breathe at that time?
I was able to breathe, yes.
Do you recall how long his hand was around your neck?
No.
But you're testifying to the judge right now that he put his hand on your neck
Yes.
right after he charged at you?
Yes.
Okay, and what happened after that?
After that, I want to say that we had another verbal argument.
I'm going to take one step back. I forgot to answer your question. How did your neck feel when he put his hand around your neck?
I don't remember how it felt.
That's fine. Okay, so then you had another disagreement. Is that what you just said?
Yes.
Like another argument?
Not necessarily argument, but well, I guess yes, we were shouting at each other.
Okay. They're shouting at each other. What happens After you guys were shouting at each other?
I don't remember. I don't remember if he was leaving at that point or if that's when he had charged me again.
Okay, so you don't remember specifically the sequence, but was there a second time when he charged at you?
Yes.
What happened during that second time that he charged at you?
He went, I don't remember if I cowered. I don't remember if I gave him my back or if he charged me like head straight, but he went for my neck again.
And was he able to put his hands around your neck this second time?
Yes.
Were you able to breathe?
Yes.
Do you remember how long he had his hands around your neck the second time?
No.
How did your neck feel that second time after he put his hands around your neck?
Honestly, I didn't have any neck pain until the following day.
Oh, okay. Right, so what happened after this second time that he charged that you and put his hands around your neck?
We got into, well, I want to say at that time, I was telling him that I was going to call the police.
And what did he do in response to you saying that you were going to call the police?
Broke my phone.
He broke your phone. Okay, what did you do after he broke your phone?
Well, I don't remember. I know he mentioned something about calling.
Objection, not responsive, Judge. The question was, what did she do?
Overrule.
You may continue to answer.
The disagreement, I know, was something he had mentioned something about like calling whoever I wanted, calling the police, calling my brothers, calling a boyfriend. And that's when he broke my phone.
Oh, so that's when you broke phone. What happened after that?
He choked me again.
So this would be the third time that he choked you?
I don't remember.
Well, you testified earlier that there were two prior times when he had choked you, right? So this is the next time. That's this would be the third time after the first two. Is that correct?
The third, yes.
Okay, so what happened this third time when he choked you?
This third time, I think that's the one where he ordered me into the kitchen.
Okay, so he cornered you in the kitchen. What happened after he cornered you in the kitchen?
And that time I couldn't breathe.
That time he choked you, you couldn't breathe?
Yes.
So he had his hands, did he have his hands around your neck?
Yes.
Do you remember how long he had his hands around your neck?
I don't remember if it was both hands or how long.
All right. Any other questions? Or do you pass the witness?
This time.
Defense?
Ms. Lavelle, you started with telling the court you were not really interested in being here to testify today. Is that right?
Yes.
And there's multiple reasons for that, correct? One of the reasons is you don't remember all the things you said at the police that day. Is that fair?
Yes.
There's another reason because when the two of you get into arguments, you both get physical with each other sometimes.
Yeah.
And you're concerned about being under oath in front of a judge, admitting to striking or assaulting my client. Isn't that true?
Objection, Your Honor, to television.
Overrule.
Well, let's go back. Let's go back to the beginning. How long did you and David live together?
I want to say 4.5 years.
Okay. And in those 4.5 years, there were previous arguments that turned physical, correct?
Yes.
And in some of those instances, you assaulted David, correct?
Yes.
And in some of those instances, you used weapons and or whatever you could find to put your hands on to assault him, correct?
What are, like,
Well, for example, there was an occasion where you hit him with a frying pan or a pan of some kind in the kitchen and split his head open, correct?
In self-defense, yeah.
So you and he have had this kind of a relationship up until you separated,
Yes.
right? And so, to be honest, he was coming over there to pick up your daughter, y'all's daughter, and take her for the evening, correct?
Yes.
And when he found that she was asleep, he changed his mind and said, I'm going to let her sleep. And he decided he was going to leave her there, right? Do you remember that? Okay. Isn't it true you told him, no, I already have plans. I was going to go out and you need to take her. I can't leave her here by herself. You don't remember that conversation?
No, I never said that I was going to leave it alone. So,
So, not that you're going to leave her by herself, but she was too young to be in the house with your older children. Correct?
no.
That wasn't a point of contention.
I did mention that I had plans that night, yes.
So the person who got upset or the problem that occurred was when you got upset to him choosing to leave the child and not take her because she was already asleep. Object this argument.
Call the roll.
But that's why I'm not having it started, I guess you're saying.
In essence, you were the first one to get upset because of his taking that position at that point.
I didn't get upset, no.
Okay. Now, when David eventually came down and had the baby in his hands, isn't that when y'all were still arguing? He never. Well, you say he put the baby down, so at some point he must have had her.
Right, yes.
Okay.
We have.
And isn't it true that you became physical with him while he was still holding the baby in his hands?
That's not correct.
Okay. But at that point you were already arguing.
It wasn't really arguing, we were just exchanging words.
Okay. Well, then what would be the need for him to put the child down? Isn't it because you were approaching him in an aggressive fashion? Okay. So he put her down so that he could commence the assault on you. Is that the position you're taking?
Right.
Okay. So, Ms. Lubano, what statement or information did you review before your testimony here today?
Like if I read my statement.
Right. Do you have a handwritten statement that you wrote that you might have read before you came down here today?
No.
Okay. Did you have a video statement that you watched?
No.
So you don't remember, you didn't refresh your memory before you came to testify about what you told the police? So is it your testimony that he never restrained you, put his hands on you or anything like that in response to what you did first?
No.
He didn't do anything.
Right.
He just unilaterally decided, I don't like the way this conversation is going. I'm just going to choke you. Is that what you're telling the court?
I requested the key for the apartment and that's what upset him, yes.
Okay. Now, did you request the key or were you being demanding or physically aggressive with him?
Yes, to answer your own question.
Call the roll.
Can you ask that again, please?
Well, the way you're saying it to the court right now, I asked for the key back makes it sound like it was a very simple, calm request.
Right.
Is that exactly the way it happened or was it a different demeanor?
Yes, I asked for it calmly. He said that he doesn't stop by unwanted or like without letting me know first. And then he asked me, why do I need it? I did become upset, told him that I don't need to explain myself.
But to be clear, Ms. Lubano, this was his apartment, correct?
Yes,
In other words, the lease was in his name.
yes,
And so he was ultimately responsible for the condition of the apartment
right,
and to return it in good order.
yes,
And so him having the key, you weren't really in a position to demand that he give it back to you. Correct.
Sustained.
But it got worse from there. Is that fair to say?
yes.
Okay. Now, you guys weren't by yourself at that time, right?
Right.
Who was there?
My 11-year-old daughter.
Okay. And your 11-year-old daughter has seen you and David fight before, correct?
Not physically, no.
Okay. She's heard the arguments.
Yes,
And on this particular occasion, she did witness, correct?
yes,
So if she would have been made available to law enforcement or to the state, they could get an eyewitness's version of what took place,
right,
who the aggressor was, who did what.
right.
Okay. But that hasn't been done. Or I'll ask another question.
Sustained.
Have you advised the state that you had an eyewitness who could corroborate your version of the events?
No.
Do they even know that?
It's in the statement that she was there, yes.
Okay. But when the various times that you come down here to talk to the state, you guys have not shared that information with her.
Or, I'm sorry.
Have you shared with the state that your daughter witnessed the events?
Object to ask and answer, Your Honor.
That'll be overruled. You can answer it.
Could you ask that again?
Have you let the state know that she was there and saw what happened?
I believe so. Yes.
Now, Ms. Lovano, this isn't the first time you've made accusations against David, is that correct?
Overruled.
You've accused him of physically assaulting you in the past, correct?
Not to the police, no.
Didn't we have a jury trial on an issue where you accused him of assaulting you, where you were a victim in the case? Sure?
Mm-hmm.
Wasn't he found not guilty on one of the counts of his trial that we had that he's currently on probation for? No?
No.
May I consult my client real briefly,
Sure.
Judge? Okay, Judge, I'll move on.
Right. So were you able to find the answer to that last question? That it was or was not her?
I'm going to move it on to something else.
Okay. So it wasn't her?
She was not the complainant in the case. Sometimes
Okay, yeah, no.
people have more than one ex.
Oh, no, I understand. I just wanted to make sure there.
Sometimes many more.
Yes.
So let's talk about the issue with the phone, Ms. Lovano. He actually bought that phone, correct?
No.
He didn't claim that he owned it?
No.
That wasn't part of the argument that, he could take it because it was his and y'all fought over the phone for that reason?
No.
Okay. So, Ms. Lovano, let's go back to where we started this questioning. We never got to the reason why you didn't want to testify in court today. Are you concerned that there's things that you told the police on the date in question that are not true?
No.
Are you concerned that he's going to be subject to going to prison over false statements you made to the police? Or misleading statements to the police? Is that part of the reason why you didn't want to testify, is that you didn't want to be put in a position of having to say things today that may or may not match what you've said in the past?
Sustained.
I think it's cross-examination, Judge, but I'll move on.
No, I mean, he's saying it's been asked and answered. So that's the objection I'm sustaining, but you can ask more questions.
On the whole, Mr. Bono, isn't it fair to describe your relationship as one where both of you have been in the wrong in terms of how you treated the other person on occasions?
Yes.
Up to and including being physical with the other person. And in a similar instance like that is what happened in October of this year.
Yeah.
And so you don't want him to be punished for maybe what both of you might have been in the wrong of doing that day. Is that fair?
Yes.
Overruled.
Yes.
You started out by telling the state that for the most part your relationship with David has been okay.
Yes.
You still stand by that?
Yes.
Do you believe that if he were to continue on probation that you and he could manage how your child was shared between the two of you without having to maybe be in the same place at the same time?
Yes.
That's what the relevance, Sean.
That'll be overruled.
Has there been a protective order issued in this case? Is that, and he agreed to that, is that right?
I'm not sure.
Okay, well, okay. But is it fair to say that there's blame to go spread around between yourself and him for what happened in October? Just ask them.
Sustained.
I'll ask you another question, Mr. Water. You said that on a couple of occasions he grabbed you. Isn't it fair to say that he's grabbing you as you're being physically trying to strike him? Objection, absolutely.
Overruled.
Are you defending them both?
Like he's grabbing you and you're swinging at him. That's my question.
No.
So you never attempted to strike him in any form or fashion. Okay. And you were totally defenseless the entire time and did nothing in terms of participating in a fight. I'll pass the witness, Judge.
All right, thank you. Okay,
Please.
sure.
Do you see the person in the courtroom that did this to you?
Yes.
Could you please point him out and describe him by an article of clothing that is wearing?
Brown.
Do you recall meeting with the police after this incident took place?
Yes.
Do you recall having photographs taken of you back then?
Yes.
That's what
Yes.
I'm handing you what has been pretty much exhibit 1, 2, and 3 for identification purposes. I'm going to hand these to you. Can you please hold them and tell me what you see in this one that's marked as exhibit in the box?
Picture of myself.
Let's move on to number 2. What do you see in this picture, Ms. Lobani?
Marks on my neck.
Let's move on to number 3. What is in that picture?
Right.
Okay. Ms. Lobani, these pictures that you just saw, they were made the same day as this incident took place? Are they a fair and accurate representation of how you appeared on this day?
Yeah.
With your knowledge, have these photographs in any way been altered? This time, your state officer evidence takes exhibits 1, 2, and 3, and I'll return to defense for review.
No objection to number 1, Judge, and Lexic on board item number 2 and 3.
All right. State's exhibit number 1 is admitted.
Now, Mr. Lobana, in regards to picture number 2, why does that look like that? Do you know, in terms of the darkness of the picture?
The lights were turned off.
Okay. Is that the same case in number 3?
Yes.
Okay. So this is a special form of photography or science that allows them to do this kind of thing. Is that right?
If
you know.
For knowledge, Your Honor.
Well, that's my whole point, Jim.
Do you know?
No.
Let me see state's exhibits 2 and 3, please.
I would suggest she's not able to sponsor these because she doesn't know what these are showing and what they mean. She's
All
never
right.
seen them before.
The defense's objection to states 2 and 3 will be sustained. State's exhibit number 1 will be admitted. Any other questions for this witness, state? Any other questions?
Yes, if I may ask for more questions about this picture, Your Honor. You testified earlier, Mr. Lobani, that these pictures questioned the day of the incident, correct?
Yeah.
They were with police. Do you recall them having to take special pictures of the areas that are depicted in these?
Objection, lead the witness, Judge.
Sustained.
Do you recall them having to take pictures of the areas that are depicted in these pictures?
Yeah.
Do you recall if the lights were on and off at these particular times?
The lights were off.
Okay. Can you tell in these pictures that this is you and this is me?
Yes, the man in that.
That's the witness, Your Honor.
All right. Defense's objection to state's exhibits 2 and 3 will be sustained. Any other questions for this witness?
None from the state.
No, Judge.
All right. You may be excused. Thank you. You can, well, no. Just have a seat in the courtroom, please. Any other witnesses?
None from the state.
Defense, any witnesses?
Objection to witness, Judge.
All right, Mr. Dwinez. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're going to need to speak up so I can hear and the court reporter can hear. You can lower your hand, state your name for the record.
Promise.
All right, defense, you may proceed.
Mr. Dwinez, do you recall the incident in October with Ms. Lobana who just left? And the two, do you agree with her that the two of you were together in the living together relationship for 4 years or more?
Sir.
And you have a child together? Okay. In what was your child's age at the time? Yeah, more or less, yeah.
I agree.
And how long have the two of you been living apart? Okay. So you knew that she already was in a new relationship, correct?
Object to reading zone.
Sustained.
Did you know whether or not she was in a new relationship? And had you ever informed her whether or not you had proceeded to a new relationship? Okay. So was there any leftover issues between the two of you, or were you at this point separate and apart permanently? What do you mean by she had issues? You need to speak up.
I was living in and back to my daughter. She said that was going on.
That's a speculation on.
All right, that'll be sustained. And I'm going to need you to speak up because I can barely hear you. I know the court reporter is struggling. All right, the objection to speculation as to the thoughts and feelings of the complainant, that will be sustained.
Okay. So what was the reasoning for you to be there that day?
She left me that called me off at work if I could pick up the baby. She had plans.
Okay. And did you agree to do that?
Yes, I was going to dinner with my partner.
Okay. And were you working that day? And so what time did you make plans to be there to pick her up? Okay. And so did you get to her apartment around roughly that hour? Okay. And what was her demeanor like, or her behavior at the time when you first encountered her that night?
She was fine.
Okay. So everything is fine. Okay. And at some point, did that change? And what caused that to happen? Go ahead, loud, David.
The baby was the night. Couldn't like girl. She started to put her house. We couldn't come back to her mom. I was off the next day.
How did she respond to that?
She said she already made plans and I was already there for me to take her. And I told her that she really wanted to had her mom emotional society. I was very vague. Since I was the girl with the money.
So you didn't leave her upstairs to sleep. You actually picked her up and we're going to take her.
Yes.
Well, what was your concern? Why did you not want to do that?
I've been home in 8 months, so she's not that comfortable with me again. So
Objective speculation, Your Honor.
Overruled.
You can finish your answer.
she not that comfortable. She has with she cries, and so I didn't want that to happen.
Okay. And did you express that to her?
Yes. So she replied that she needs to get used to me, so I need to take her.
Okay. And at some point, did the tone of voice between you or her change? Okay. And then what proceeded to happen next?
And that I whatever I want, and
Objective to hearsay, Your Honor.
Overruled.
So she's cursing at you. She's upset with you. And what happens next?
she told me about money. She wanted money and how much spending rates with my son. Like giving her money to her apartment and helping her out.
Okay. So even though the two of you had separated, she's still living in an apartment that you're financially obligated to pay. Is that right?
Objective leading, Your Honor.
Overruled.
So all these things start coming out from her complaints, suggestions, comments, whatever you want to call them, after you told her you were going to leave the baby.
Objective leading and revocation.
Overruled.
You tell the judge, David. Tell me what happens after you tell her that you don't want to take her in that condition she was in at the time.
Wow. I think giving up time for the baby and helping her out. That's it. This part of how she let me, so that made her mad. He was continuing to argue back and forth on the kids. And, she was in a car with him.
Okay, so what did she do next? Okay, she grabbed your phone? Okay. So why was she grabbing your phone if you know?
This girl grabbed it.
Objective speculation.
Overruled.
Has she ever taken that tactic with you in the past when you guys have argued?
She could.
Now, I asked her the question about whether or not she'd ever been physical with you. What is your answer to that question?
Very well.
And so when I say that, describe for the judge the kinds of actions she's taken against you in the past.
And on my head in front of the children, and that's when I thought I had nothing.
Now you say glass pan. Describe it for the court.
That's so text.
Okay, so it's like a dish that you would store food that's cooked in. Okay. Did it break? And what was the injury that it caused to you? And did you file a police report as a result of that? Okay. Is this the first time that she'd gotten to that extreme with you? So that was the last day that the two of y'all were together? Okay. Now, you heard the way she described the way that you were acting that day, correct? She characterized it as you charging at her. Did you do that?
We were fighting on the phones. We discussed this. We didn't charge her.
So it was strictly the two of you. Were fighting over your phone or fighting over hers, or both?
Well, she had mine. I had her. But he's trying to avoid.
Okay. So at any point other than trying to get your phone back or taking hers, did you put your hands on her? Okay. She talks about being cornered in the kitchen. Did the tussle or the back and forth over the phones move around the apartment?
I'm not charged for the phone. She would walk back and then try to get my phone. But we still put back and forth.
Okay. You heard me ask her about her 11-year-old. Where was she at this time?
Watching.
Well, when you say she was watching, where was she?
No,
So in the same room y'all were in. Would you say she was there the whole time? Are you on good terms with her?
Objective irrelevance, Your Honor.
Sustained.
To your knowledge, something else. Why did you leave after this all kind of, I guess, calmed down?
she gave me my phone back so I little kid, and I broke her. The daughter started crying and hugged her angry, and I grabbed my phone and I left.
Now, the phone that you broke, was that your phone, or, who owned the phone? Okay. So she was using it, but, okay. You understand, that probably wasn't the best move. Okay. But did you throw it at her or strike her with it or anything like that?
My phone got left it here.
Okay. Now, since she's gotten this protective order, has she reached out to try to communicate with you?
Object Mr. Relevance, Your Honor.
Overruled.
Since the protective, well, let's go back. Did you agree to a protective order with her? And when did that happen? Okay, so sometime after October. And you agreed to it in the sense that you signed off on, is that right?
Yeah.
Now, even though you got that order, has she still tried to communicate to you directly or through another person?
Object Mr. Relevance.
Overruled.
Has she tried to get messages to you or to communicate with you even though the protective order is in place? Did she contact your family? I'll pass away, Judge.
State?
Mr. Dwinez, you have animosity toward Ms. Luano, correct?
I don't know what that word means.
I can't hear you. I'm sorry. Can you turn towards me?
I don't know what that word means.
You don't like her really anymore, do you?
I still love her. Mother of my daughter.
I can't hear you again. Could you,
I still love her. She's the mother of my daughter.
you have anger towards her, right? You don't have any anger towards her at all. So you just left because you just wanted to leave, right? Because it was a happy situation for you to leave, right? You were happy in doing so. You weren't angry at all at her because of what you're saying she did to you, right?
From that day? From what day?
Okay, well, let me help you out then. You were testifying earlier with Ms. Martinez asking you questions that you don't live with her anymore, right?
Yes.
If you had moved out, right?
Yes, sir.
You were angry in doing so, right?
I was just sad that our family is broken, so I left. There's nothing I can do.
There was nothing at all you could do to try and make things better, right? You certainly couldn't act better on your end towards her, right?
Because I moved, I made my decision to get away from her.
Okay. So because of that, and you having to now live somewhere else, this is an inconvenience for you then, right?
Oh,
Okay. You have to make arrangements with her whenever you want to see the child that you have in common then, right? No, you don't. So you just go whenever you want to over there?
you said yes or no, and I don't argue.
Right, exactly. Those are arrangements that you're making with her to see the child, right?
Oh, yes.
Okay. So on this day, you had made an arrangement to go and see your child then, right?
She made an arrangement with me.
So you never reached out to her first?
She reached out to me.
She reached out to you, okay. So, but you still said, okay, I'm gonna go and see my daughter then, right?
Yes.
You went over there after work, as you testified earlier, right?
Yes.
Okay, and when you got there, you went to go and see your daughter, right, who was upstairs sleeping?
Yes.
Okay. And after that, you brought her downstairs, right?
Yes.
Was she still asleep at that time?
Yes.
All right. And then there was an argument that took place between you and Miss Lavanu, right, about a key to the apartment?
More things too, but yes.
Okay, well, that was one of the things you argued about, right?
Yes.
And you didn't want to give it to her because it's your apartment, right?
Yes.
Because in your opinion, she doesn't have a right to have a key to the apartment that she lives in with her children, right?
She was moving out.
Well, at the time it wasn't though, right?
No,
The time it was active,
the lease was ready to expire, and
it was expired, so you were allowing her to live there after at least that expires. Is that what you're saying?
yes, because she was moving out. She said,
Okay, so the apartment complex was aware that there's someone living in this apartment that's not on the lease.
yes.
Okay, that's what you're saying. All right, so you get there that day and you guys have this argument about that makes you angry, right?
No.
You didn't get angry about anything. Okay, so you're calm, having a conversation with her the entire time.
About the key, I wasn't upset.
Okay, but okay, other things then upset you then, right?
But
Yeah, you got upset, so you went at her, right?
no,
You never went at her? You never put your hands on her neck? Never choked her at all? Never lifted her off the ground with your arms around her and on her neck?
not that strong to lift her off the ground. No, I would never.
Okay, so you never did that. That's not true.
No, it's not true.
Okay, but so the only thing you did is grab her phone and smash it then, right?
I just grabbed my phone.
After she grabbed yours. So you grabbed yours in retaliation and you smashed it because you felt like it's your phone and you own it and you can do whatever you want, right?
Yes.
Okay. So, and this was done in front of her children there, right?
Yes.
You felt like that was appropriate behavior to act like that in front of two children?
No.
You still did it anyway though, right?
Yes.
Okay. One of them being yours, right? Okay, so it didn't matter to you at that point how that might affect them, right? You were just too angry to care about that. Okay, so you just snapped the phone in a calm, nice manner, right?
Father's very trying to get out.
Wanted to get out, so you did that. You just got out there and you left your child there, right?
Yes.
At that point, you didn't care. You just wanted to get out.
Yes.
Okay. And you're obviously aware that you're on probation for a case that you had gone to jury trial on, right?
Yes.
And is it important to you to keep up with the terms of this probation?
Yes.
Because you want to be on probation.
Yes.
You want to do well on probation.
Yes.
And you felt like this was the appropriate way to show that you're doing well on probation?
That's why I wanted to leave that date. That's why I was trying to leave.
That you were trying to leave, even despite all this stuff, you were wanting to leave because of your probation.
Because she kept saying she was going to come leave.
Did you ever call the police that day to tell them your version of what happened?
No, because I didn't hurt her, so I wasn't aware of anything. I just thought it was, I didn't hurt her. She didn't hurt me. I just thought we would just talk to each other and just blow it over. And she'd apologize because she always does. She'll apologize. And we try to co-parent. That's all I thought was going to happen. I didn't hurt her. I didn't do anything to her, so I didn't think of anything was going to happen.
All right. Any other questions?
From the state.
Any follow-up questions?
Not on the allegations of number one, Judge. No.
All right. Any other witnesses from either side?
None from the state.
Judge, I would have questions for probation, but not as to the truth or not untruth of the allegations of number one, just depending on if that's necessary. But I was simply going to ask,
No, what questions you
well,
have?
just like how he's doing on probation, whether he's all the things he's supposed to be doing, things like that. But
All right.
I don't remember his name, Judge.
Do you recall?
That's fine.
Yes.
Yes.
Williams?
All right. You're still under oath. Defense tells me they have some questions. They just want to know how Mr. Dwinez was doing on probation other than with this allegation.
Your Honor, he was doing fine. He was showing up on time for his virtual visits. Unfortunately, he tested positive for cocaine and cardiac effects. Other than that, he showed up on time.
Well, but he's done more than that, to be fair, right? He's completed classes, correct? Matter of fact, you have a listing of all the things that he's completed. You can tell the judge all the things he's completed on probation.
So he's completed letters of intervention, GPS. He provided a DNA sample on his parenting class.
What about community service?
Yes, he's completed community service.
Well, how's he done on those payments?
So he made payments. He does have a balance of $3,712.
Okay, but that includes probation fees that are due in the future, correct?
Correct.
How much has he actually paid towards probation?
So he's actually paid $244.
Okay. Now, isn't it true that you advised him that because of all the things he's completed, and if he got current with his probation fees, that he might be eligible for early termination?
Reject his testimony, Mr. Honor.
Overruled.
I know.
You didn't have that conversation with him? Okay. Who did he have before you? Or did he have somebody before you? It's better.
Yes.
Okay, and so you've only been on the case just a couple
2
months. Okay. That's what it should.
I have no
right.
questions, Your Honor.
Thank you so much. All right. With regards to violation of condition number 2, the court is finding it not true. The court will note for the record that the probation officer did state that Mr. Dwinez, I believe, tested positive, but the court is not considering that because I know that the defense was bringing the witness strictly for the purposes of how he was doing on probation and with regards to whether or not he tested positive for cocaine. Lab reports would need to be presented and the person, whoever is responsible for doing the testing, would need to come in and testify. So that'll be found not true. With regards to violation of condition number 1, the court is finding violation of condition number 1 true. Is there a request from the state?
Yes, Your Honor, that request is to revoke the defendant's probation and sentence him to 2 years in prison.
All right, defense.
Well, clearly, Judge, we're not in agreement with that. And now that you've heard the testimony in the case, you can see why we're anxious to take this case before a jury and get a determination after a full and complete trial of all of the issues with all of the witnesses and other evidence that's relevant and admissible in court. Due to his performance on probation, Judge, and his obligation in terms of support, his voluntary acquiescence to the protective order, we'd ask the court to employ one of the many sanctions that the court has available and to keep him on his probation. If nothing else, at least until we resolve that new charge. The state's going to have another shot at him. In that case, they can ask for the full range of punishment, and they won't be limited to the 2 years that the court has in this situation. I think Ms. Levana was honest when she said that it's a two-way street. And she was being very kind to herself about that. When you smash a pot over somebody's head and embed glass into their shoulder, that suggests you the type of person that she really is. And why she admittedly was reluctant to come and testify in court, because there's things that she's done and contributed to this situation happening in October that she's not proud of either. I think they both are embarrassed that all this had to come to light in public, and they both could have done better and handled the situation. And so, Judge, in light of everything, rests in the court not to revoke his probation and to consider other alternatives.
All right. And counsel, have you completed the trial court certification?
I have not, Judge. I've been kind of busy last year.
Oh, if y'all will complete that for me, please.
So, watch to any portion of vote by signing because if you understand that you have limited rights to appeal.
All right. The court is going to grant the state's motion to revoke. The court will sentence you to 2 years in the prison, giving credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Danessa Dwinez, Christian Rodriguez, and Charles Watterson. And that's from the previous conditions that were given when you were placed on community supervision by the jury. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? You do have a right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you're in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Okay? All right. Good luck to you, sir.